Welcome to the Language of Law. This series explains how legal language shapes what people are allowed to understand about justice. Part 4, Appellate courts cannot find facts. Most people hear the word appeal and assume it means a second trial. It doesn't. Appellate courts do not hear witnesses. They do not watch the jury. They do not decide who is lying and who is telling the truth. They review a paper record, so when you say, "The jury got it wrong," an appellate court usually can't fix that by redeciding the facts. What they can do is review whether the trial court followed the rules, whether the law was stated correctly, whether the instructions were lawful. But here's the hard part. If the jury instructions were confusing or contradictory, or allowed the jury to convict without agreeing on the same essential facts, an appellate court is often boxed in, because appellate judges are not allowed to rewrite the trial. They can correct legal error, but they cannot do the jury's job after the fact. That is why the language used in jury instructions matters so much. Once the verdict is in, fixing it on appeal is not the clean reset people imagine. Next, we're going to talk about the limits of appeal and why procedure can matter more than truth.